My name is Mark Evans. I'm the National Practice Group Leader for Dentons Litigation and Dispute Resolution team in Canada. By way of a very brief introduction, my practice focuses on class action, fraud and asset recovery, and financial services related litigation. And I've been with the firm for best part of 24 years. I'm pleased to be the moderator for what we anticipate will be a very interesting and informative session for you all. It won't be a surprise to anybody on this call and on this session that the landscape in which we all work, practice, and live has become increasingly complex over the last 12 to 15 months, increasingly volatile in many respects, both from an economic perspective, and also we are seeing increasingly from a regulatory perspective for perhaps obvious reasons. That volatility has led to a significant increase in dispute resolution work that we are seeing, both on the litigation side and on the commercial and international arbitration side. That litigation and that dispute work is coming in a number of areas: employment, privacy and data, regulatory investigations, class actions. Fraud is certainly on the rise, and ESG related litigation, while not on the rise because it's a relatively new thing, is certainly becoming more prominent and prevalent in the practices and in the work that we are doing with clients, both across the country, but in other jurisdictions as well. With that background in mind, our intention is to provide an overview of the trends that we are seeing across those areas, and ideally some practical and key takeaways to help all of the folks on this call manage and perhaps moderate the risks in your day-to-day practices and business operations. So with that, I'll turn it over to my partners, Chloe Snyder and Emma Irving, who are going to touch on some recent developments in the class action space in Canada.
Good morning. My name is Emma Irving, and I'm a partner in the Vancouver Litigation and Dispute Resolution Group. I do general commercial litigation with one area of focus being class action defense work. As Mark mentioned, today my colleague Chloe and I are going to talk to you about some of the trends we are seeing in the class action sphere. I'm going to start by talking about a few cases that have arisen recently in the product liability area. The first point is that it can be important when companies experience a product liability issue to consider early on whether it's appropriate to issue a recall with respect to the defect. Now, there are a number of different reasons why a recall can be a good course of action for a company, such as reducing potential damage claims or helping with PR. But another benefit is that it can, in the right case, it can provide a basis for a court to deny certification of a class action. And this is what happened recently in the case of Coles versus FCA Canada. That case dealt with a defect in a car manufacturer's airbags. And there, the court declined to certify the matter as a class action against the manufacturer on the basis that a class action was not actually the preferable procedure for dealing with the plaintiff's claims. And the court found that the manufacturer's existing recall program was actually the preferable procedure. And in that case, it's important to note that the other four aspects of the certification test for class actions were actually met. But the manufacturer was able to avoid certification altogether because they had already implemented a robust recall program. The next item we wanted to raise is that when a class action is based entirely on alleged regulatory breaches, such as a false advertising claim, a company that can show that there were no actual breaches may be able to effectively deal with a class action through a summary judgment application. And this was done recently in the Reebok versus Ford Motor Company case. This is an Ontario case that was actually recently affirmed by the Ontario Court of Appeal. And in that case, the allegations related to the energy guide labels that were affixed to certain Ford vehicles and their marketing materials, which the plaintiffs alleged were false or misleading under the Federal Competition Act. There, the action was certified on the basis of common issues that related entirely to whether Ford had breached the Competition Act. However, the court then, on a summary judgment application brought by Ford, dismissed the claim entirely on the basis that Ford had actually complied with the applicable government regulations. And in fact, the court found that Ford had carefully complied with the federal government's guidelines and had not, as the plaintiffs had asserted, knowingly or recklessly made representations to the public that were false. So while Ford wasn't able to avoid certification itself, they were able to have the class action dismissed early on before having to go through the full merits of it by bringing a summary judgment application and showing that they had not actually committed alleged breaches of the Competition Act. The last point we wanted to briefly touch on with you is before turning things over, is that we need to keep in mind in our current multi-jurisdictional landscape that the courts will not automatically stay a duplicate or overlapping class action on the basis that the later action is an abusive process. Now, this point is not unique to product liability cases, but it can be very relevant in the product liability area because often allegations are quite similar between overlapping proposed class actions. And while it can be frustrating for defendants to be faced with multiple proposed class actions, often brought in different provinces, and there are circumstances in which the court will stay one of them, it's important to be aware that the court in Kearse versus Bristol and Myers recently found that there's no presumption that a duplicate class action should be stayed unless it offers a benefit to the plaintiff class. And the court will look at a number of different factors when considering whether to stay in action, with duplication only being one of them. Other considerations include benefits to the class members, the history of the matter, and the relationship between the two proceedings. What this means is that defendants cannot assume that they will be able to get a second class action stayed, particularly when brought in a different province, and they may have to actually work to deal with more than one class action at a time. And with that, I'll hand it over to Chloe.
Thanks, Emma. My name is Chloe Snyder. I'm a partner in the litigation group in Toronto. My practice focuses on complex commercial and corporate litigation, including class actions in the privacy and competition law areas. So I'm going to be touching on first privacy and then employment law issues in the class action context. And there continues to be movement in both of those areas and increased litigation, or at least increased decisions as these cases wind their way through the courts. So dealing first with privacy, there's been a lot of movement in the last year or so, which I would say is overall friendly to the defense side, which we are generally on, although not entirely. And so why do I say this? The first is a trilogy of cases from the Ontario Court of Appeal decided toward the end of 2022, dealing with what is generally called database defendants. So defendants who, for commercial purposes, have collected and store generally their customers' personal information, and then who are accused of failing to have taken adequate steps to protect that information from third-party hackers. And so there were three cases that went up to the Court of Appeal sort of together where this was an issue. So that's the Equifax, TransUnion, and Marriott cases. Two of them were certification decisions, and in Marriott, it was a motion to strike. And so the issue in these three cases, and really in the privacy class action certification context generally, as it concerns the common law tort of intrusion upon seclusion, is whether or not a database defendant who is not the third-party hacker who has done the intrusion, whether or not they can be held liable under the tort under the reckless component of the tort. And so the tort of intrusion upon seclusion was established by the Ontario Court of Appeal in 2012 in the Jones case. And there the court held that the tort will be found to have been established where a plaintiff can establish that the defendant has intentionally or recklessly invaded without lawful justification a plaintiff's private affairs or concerns, such that the invasion would be regarded as highly offensive to a reasonable person. And they don't need to establish damages. So the issue really has been at the certification stage. What do you need to plead in order to establish either this intentionality or this recklessness that's a component of the tort? And in each of these three cases that went up to the Court of Appeal, the Court of Appeal concluded that it was not enough to say that the defendant who had collected the information hadn't adequately protected it. The defendant actually had to be involved in the intrusion. or potentially be vicariously liable for the intrusion. And so we see in each of these three cases, the courts pushing back on what had been, in my view, a trend of certification decisions that had said, you know, the certification stage is too early really to decide what the claims may or may not be that are made out, so we'll let them through. And so here we have the Court of Appeal saying that on intrusion upon seclusion, the reckless component doesn't really open the floodgates to the more innocent party being the subject to an intrusion upon seclusion claim. Now, that doesn't mean that other claims, for example, claims based in negligence, won't succeed. So it's not that parties who don't adequately protect their customer information won't be the subject of a claim, but there is an important distinction in terms of the damages component between intrusion upon seclusion and negligence, such that because you don't have to prove damages for intrusion upon seclusion, if you have a database of 500,000 people with moral damages each of 100,000, you can see how those numbers can get pretty high without even having to establish damages. So it's an important development, but not a full answer to the obligation to protect client information. It also doesn't address vicarious liability for employee conduct, which I'll get into in a moment. The other important decision from 2022 is the type of information that can be subject to an intrusion upon seclusion claim, which is that it really does need to be the type of information that would result in something that's highly offensive. And so we have the Stewart and Dem case where patient information was accessed by a nurse in order to basically steal drugs. And the divisional court, on an appeal from a certification motion decision, found that the fleeting, as they call it, intrusion did not arise to something that was highly offensive, and so denied certification on that basis. I could talk about these cases at length, but I don't want to hold up the rest of my colleagues. So I'll move on to the employment cases, and really the first case that I'll talk about really ties into the privacy class action space, and is one of the reasons why I say that the landscape isn't totally favorable or wholly favorable to defendants, because in the Ari and Insurance Corporation of British Columbia case of the British Columbia Court of Appeal, we see that the defendant in this case is held vicariously liable for the conduct of its employee who accessed and misused information of 78 customers and then sold that information to criminals who then engaged in arson and other attacks on the homes and cars of these customers. And so that class action was certified and then went to a summary trial last year, which was successful on the issue of liability. The issue of damages wasn't determined, but this is one of the first cases that has gone to a merits hearing in the privacy class action context. And so it is an important development in that sense, and I think shows, you know, the issue of vicarious liability for employee conduct as being a really important one for organizations to consider as they think about what privacy protections are in place. Because in that case, although there was a privacy policy, there was nothing in place to enforce the policy and make sure that the employees who had access to customer information weren't subsequently misusing that for nefarious or really any purpose that wasn't consented to. And so that is an important decision in terms of what organizations need to be thinking about in terms of privacy risks that could result in class actions. The other area where there's been some development in the employee class action context are claims either about classification of employees versus consultants, and claims for benefits or enforcement of rights or obligations under employment contracts. And so the Lewis and WestJet Airlines case, also from British Columbia, is an example of that, and ties into some of the preferable procedure issues that Emma was talking about. But that case, very briefly, because I'm running out of time, related to claims to seek damages relating to the alleged breaches of anti-harassment commitments in class members' employment contracts. And in that case, the defendant had made the assertion under the preferability analysis, which is one of the 5 requirements for certification, that a preferable procedure was actually the Canadian Human Rights Tribunal. And so the motions court had refused certification, agreeing with the defendant that that was the preferable procedure, and that got overturned on appeal, where the British Columbia Court of Appeal found that that was indeed not the preferable procedure for a variety of reasons, including the applicable limitation period, including that the tribunal had the ability to decline complaints, and there was no ability to have the complaints adjudicated on a group basis. And so really highlights the importance of really being able to present to the court a viable, preferable procedure mechanism in order to defeat this requirement of certification. And so with that, I will turn it over to my colleague, Mark Glynn.
Thank you, Chloe, and everyone for joining. I'm Mark Glynn, counsel in the Toronto office, and I have an eclectic practice encompassing products liability, class actions, and general commercial litigation. I'm tasked in 6 minutes to cover a rather broad spectrum in discussing privilege, which refers to rights to protect communications from disclosure in legal proceedings. However, this session would be incomplete without this conversation, as my colleagues and I in 2022 and before and beyond are repeatedly confronted with situations where we're disclosing, pursuant to discovery obligations and lawsuits, documents that in an alternative universe could and should have been protected by privilege. And those disclosures of documents have, in certain cases, handled in 2022, fundamentally changed the character of lawsuits for the worse for our clients. The common theme is very much not that it's the law department that's misunderstood or overlooked privilege, but rather that they do not have the opportunity to intercept, and any harm has already been realized before the law branch can weigh in. That's not, however, an absolution of responsibility, as it's our common mission as internal and external counsel to instill, repeat, and reiterate over again to business units a culture that recognizes the importance of privilege and develops reflexes to query whether correspondence, records, investigations could one day be problematic, and to query whether they would like at least the option down the road of shielding the contents from scrutiny in the event of a lawsuit. At this juncture, I recall a mediation in 2022 where we appeared with our client before the former Associate Chief Justice of Ontario. We had an initial caucus where we presented a well-structured, logical narrative, our theory of the case with threshold issues, absolving our client of liability. The mediator was on our side when he left the room. However, not unanticipated, he returned after looking at records produced by us and relied on by the plaintiff, documents that could in an alternative universe have been protected by privilege, and the mediator was unequivocal that our client needs to settle the lawsuit, notwithstanding the merits of any arguments we'd raised. What then are the key classes of privilege and the takeaways we want in-house legal departments to be giving as a high-level best practice for the business units to retain? Post-client privilege refers to the cloak of privacy that exists between clients and their lawyers, whether internal or external, in the course of provision of legal advice. The latter qualification is often overlooked, and the risk is that, as a matter of complacency, the business thinks that simply copying a lawyer in a CC line of an email establishes the magic of privilege and the document is forever private. The business unit and the lawyer must be thinking about what communications are copied to the lawyer only for visibility, or provided for policy or business advice that the lawyer adeptly gives, but that don't amount to the legal advice that the condition precedent of attaining such a client privilege, which is permanent, surviving litigation subject to waiver. While the test for establishing any privilege is one of substance, not form, so there's no real magic to marking a correspondence as privileged, it's helpful when corresponding with business units to label the correspondence as such and to provide timely reminders to the business that privileged materials should be treated with a high level of sensitivity, limited internal distribution, and no external circulation. Litigation privilege attaches to communications created for the dominant purpose of litigation, where litigation is contemplated, anticipated, or ongoing. Litigation can sometimes save the day where the client privilege isn't established, but it's dangerous to have a business unit think like that, given that there are various obstacles to overcome to establishing litigation privilege that don't apply to solicitor-client privilege. And it's also a poor relation since it expires at the completion of the litigation in issue. The biggest threshold to overcome in establishing litigation privilege is the dominant purpose test, and whether communications are made for the business or other purposes, as opposed to litigation strategy specifically. As a best practice, we recommend in the course of internal investigations to seek guidance of external counsel to confirm if litigation is a reasonable prospect, and ideally for external counsel to conduct the investigation. Settlement privilege refers to communications made with an opposing party, but with a view to resolving the issues by way of a compromise, which protects the communication against disclosure to the court. Again, there's no magic to the words without prejudice on a correspondence. It does no harm, but the real test is whether the communication pursues a negotiated resolution of a dispute. A quick word on common interest privilege, which is sometimes construed as its own class of privilege or as an exception to waiver, as there needs to be an underlying other privilege. This allows two parties to cooperate in litigation or prospective litigation in which their interests are aligned, typically between defendants. As a best practice, an agreement should be reached in writing between the parties that sets out the common interest and that clearly sets out the expectation of confidentiality of information or records shared and survival of the confidentiality if the agreement is terminated. Privilege can also attach to a document by virtue of legislation. This is a statutory privilege. It's relatively rare. It's not something our clients can influence since the privilege attaches or does not, and it does not subject to waiver. One instance of this is the Transportation Safety Board Act that governs the TSB, in which shields certain communications from disclosure or use in legal proceedings in order to protect other public policy interests regarding the investigation of safety incidents. Such privilege exists for onboard recordings, also known as black box recordings in the context of an aircraft, and that capture the communications in the cockpit. The statute establishes a qualified privilege, which means that a court has discretion to order disclosure in the civil proceedings. This issue reached the Supreme Court of Canada in 2022, which issued a decision that very liberally construed the discretion of the court to order disclosure in the court's quest for truth to the expense of the competing public policy interests. I cannot do justice to the decision in the time that we have. My colleagues and I have written about it, and you can read that. And it's certainly too early to establish a trend. However, if a trend were to emerge that marginalizes privilege in favor of courts' search for truth, there'd be no better source for that trend than to develop from the Supreme Court's decision. I'll now hand over to my colleague from Toronto, Arab Asmadjan.
Thank you, Mark. My name is Arab Asmadjan. I'm a partner in the litigation department in Toronto. My practice involves a variety of corporate and commercial litigation matters with an emphasis on product liability, class actions, and shareholders' disputes. I'll be speaking to you today about the disclosure of partial settlement agreements that change the adversarial landscape of the litigation. In 2022, the Court of Appeal for Ontario released a series of decisions confirming that the failure to immediately disclose a settlement agreement that changes the adversarial nature of the litigation constitutes an abusive process that will result in an automatic and permanent stay of the action. If the settlement agreement changes the adversarial landscape of the litigation as set out in the pleadings, then it must be disclosed on an immediate basis. The length of the delay in the disclosure or the lack of prejudice to the non-settling defendants will not avoid the draconian consequences of a permanent stay as a result of a failure to comply with this procedural rule. According to the court, part of the reason for a bright line rule was to avoid interlocutory proceedings which only serve to increase the expense of the litigation for all parties. Now, the Court of Appeal has also clearly stated that disclosure means disclosure of the terms of the settlement agreement as opposed to mere notice of the settlement agreement or information about the agreement. Although any monetary amount provided for in the settlement paid is privileged and need not be disclosed, The key features of the agreement must be disclosed to the non-settling defendants and ultimately to the court. The court will compel production of the actual settlement agreement to the non-settling defendants who request it. The Court of Appeal has confirmed that a breach of the disclosure obligation will result in an automatic finding of abuse of process and a stay of Ontario proceedings. The failure to immediately disclose a settlement that changes the landscape of the litigation, resulting in an automatic stay, is a trap for the unwary, as it leaves no room for judicial discretion, which appears to be unique to the law of civil procedure in Ontario. One of the hallmarks of a change in the dynamics of litigation is where one party, a co-defendant, for example, starts giving an affidavit in secret to the plaintiff, whereby they're essentially aiding the plaintiff in the prosecution of the action against the other defendants without disclosing that fact. Now, in my view, these decisions create unnecessarily harsh consequences, as even an inadvertent or a harmless breach of the immediate disclosure rule involving a short delay, a delay that's even in the case law a week long, will cause a plaintiff to automatically lose its right to litigate its dispute on the substantive merits without any finding of prejudice to the non-settling defendants or judicial remedial discretion. So the punishment may not always fit the crime, and a more balanced approach would have seemed appropriate. Now, while a bright line rule of immediate disclosure and an automatic stay in the event of breach has the advantage of simplicity and creates a powerful incentive for compliance, it may not always be capable of predictable and consistent application in modern civil litigation. Even with the best of compliance intentions, perfect compliance may not always be achieved, and that forces the court to grapple with many facts, including quickly initiated but incomplete disclosure that is supplemented incrementally with delay. In one case in this series of decisions, the Court of Appeal was satisfied with the immediate disclosure of the essential terms of the settlement agreement, notwithstanding the fact that full disclosure of all the settlement terms and documents was piecemeal and incremental, although it commenced the day after the settlement agreement was signed and 2 days after it became effective, and involved a promptly advised motion for court approval of the partial settlement agreement. The unintended consequence of the inflexible automatic stay of proceedings approach with no judicial remedial discretion has been confirmed by the Court of Appeal in some 7 decisions. It has the potential to create bad policy and unjust outcomes. Defendants are encouraged to take advantage of even minor steps by plaintiffs. And in that context, the Court of Appeal's stated justification for the clear principle or bright line rule rings quite hollow and undermines the general principles of Ontario's rules of civil procedure to secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits. The Supreme Court of Canada's dismissal of the leave to appeal applications from several of these cases appears to close the door on any hope of recalibrating the principles that emerge from the Ontario series of decisions or bringing uniformity across provinces to the procedural common law in this regard. It remains to be seen whether Ontario's strict approach with automatic draconian consequences will remain unique to the procedural law of Ontario, or whether other provinces will revisit their discretionary approach in light of the Supreme Court of Canada's dismissal of the leave application. In the meantime, all Ontario litigators and in-house counsel who manage litigation in the province must be familiar with this strict procedural rule, the breach of which will result in what has been described as the equivalent of capital punishment in civil litigation, a stay of proceedings. It's my pleasure to now hand things off to my colleague, Thomas O'Leary, who will speak to you about environmental litigation. Thank you.
Thank you very much, Ara. Good morning to me and good afternoon to others. I'm Tom O'Leary. I'm a partner in the Calgary office of Dentons, and I'm in our civil litigation and dispute resolution group. Within environmental litigation, 2022 reinforced a couple of trends. One, the trend toward climate-based litigation, and secondly, reaffirmation by the courts of some of the traditional private law principles as applied to and forming obstacles to success of broad environmental litigation claims. Much of the attention in this area was and continues to be on what can be described as public interest litigation, that is, litigation undertaken to affect change in policy and social behavior, rather than specifically to benefit the litigants themselves. Much of this public interest litigation has been directed against governments and anchored in the concept that the governments have a legal obligation to act to protect the environment, whether that is by virtue of legislating or enforcing existing legislation in a certain way. Of note, in one particular respect, the claimed rights to a healthy environment. Many other jurisdictions outside of Canada have recognized these as basic human and constitutional type rights. Canada has yet to do so, though. For example, the Ontario Environmental Bill of Rights recognizes that concept, and it's being pushed in a number of cases before our courts that are bubbling up to a decision-making level. The types of cases, these public interest type cases, particularly those based in climate litigation, raise fundamental issues of justiciability, as well as the scope of the rights claimed, whether those are constitutional or otherwise. Justiciability essentially is challenged often by defendants, by governments, on the basis that these claims are really not the place of courts to determine, but they are the place of legislatures to determine. And that segues a little bit into the second trend, the trend of private law principles being reinforced by the courts. Claims against private actors or government in terms of based on private law in the environmental field are generally based on tort law, when whether that tort is a breach of a statute or otherwise. There are a number of interesting cases pending or potentially pending in that area. For example, the city of Victoria, it's been well publicized, has passed a motion to bring such an action against the oil and gas industry, although the action has not proceeded yet. The city of Vancouver has passed a similar motion and has begun collecting funds to finance that kind of claim. The city of Toronto has commissioned a report to consider the possibility of that type of claim. Those are things to watch going forward for certain. These types of claims and other broad environmental claims against industry in particular will be challenged by traditional legal concepts of causation and the compensability of certain types of damages. Civil causation, as we all know, is established on a but-for basis and on the balance of probabilities. The difficulties in proof of such causation in climate change litigation, for example, are fairly obvious. Climate change is, of course, a global rather than local phenomenon, making it inconvenient, to say the least, for evidence to be brought to demonstrate causation against any particular actor. Private law limits on damages recovery, and in particular, pure economic loss recovery, are proving another relevant concept here. The case cited on the slide deck, an Alberta Court of Appeal case from 2022, Ryger versus Plains Midstream Canada, arose from a pipeline spill, and the pipeline, it was crude oil. The oil migrated quite a long ways downstream along a river to a lake, requiring significant remediation. Class action was brought by a group of property owners all around a fairly broad geographic circle around the actual spill footprint, and those claims were rejected on appeal on the basis that they largely dealt with only economic loss, and the only appropriate plaintiffs or class members were those whose lands were physically impacted, and those were extremely few in number. resulting in the decertification of that class on appeal. It's one example of how traditional private law principles have been have been affirmed and have been used effectively to limit the scope of environmental claims. One other, of course, causation I mentioned, defenses based on compliance with existing statutes and regulations are another area where those defenses have been raised in many cases. Not that many have gotten to the point of determining them yet, but one can expect that trend in terms of the primacy and the emphasis on private law principles to be continued in 2023 in environmental claims. So the takeaways going forward, as I mentioned at the outset, there were continuing efforts to anchor public interest environmental litigation in rights, in particular a right to a healthful environment. And secondly, what seems to be a reluctance of courts in Canada to change or qualify basic private law principles to accommodate environmental claims, essentially signaling to litigants that broad environmental issues such as climate change are more appropriately determined in the realm of constitutional law or in the forum of the legislatures. Thank you very much. I'm going to turn things over now to my colleague, Sean Stevenson.
Thank you, Tom. Hello, everyone. Good morning, good afternoon. I'm Sean Stevenson. I am counsel in the Toronto office, where my practice focuses on international trade and investment. And today I'm going to talk a little bit about supply chains. Given that we're about halfway through, if you want to stand up, take a stretch, little 7th inning stretch, always helpful to keep powering through these long sessions. Supply chains have been a hot topic over the past few years. For a while, we couldn't open a newspaper without hearing about supply chains, whether that's in relation to COVID, whether that's relation into geopolitical events or friendshoring. It's been all over and top of mind for a lot of folks. With all of those changes, we've also seen an increasing number of disputes and investigations in relation to a company's supply chain. And we're also seeing a large number of pieces of legislation coming online here in Canada, but also globally as well. So we're seeing a real sea change in how we think about supply chains and legislation that governs supply chains. And with that, of course, we've seen disputes or at least dispute resolution processes having been initiated or contemplated by parties on a global scale. So today I want to talk about three things which are acutely relevant to your supply chain in 2023. These are based on trends that we have seen develop over the past few years and trends that are emerging starting with last year, moving into 2023 itself. So the first thing I want to talk about is price. Price. How do we deal with this when everything is getting more expensive? We've seen an increasing number of disputes based on pricing and the increase in prices that it takes to procure goods or to manufacture goods. And there's two. Well, parties will flesh those out and try to renegotiate or come up with new deals. I want to flag two sort of key provisions that you should be thinking about in your contracts that are either in place right now or that you're negotiating, and that's escalator clauses and fluctuation clauses. These provisions can really assist, particularly with inflation. We know that in Canada, inflation was about just over 6% last year. And this is particularly important for long-term supply contracts. So when you have a long-term relationship, how are you going to govern that relationship when pricing or labor costs start increasing exponentially? So fluctuation clauses in contracts allow for changes in price, and this can cover a multitude of different things, from changes in taxation, changes in costs of labor, transport, materials, head office costs, and they can even be indexed to inflation. So to the extent that you're a manufacturer, and you have an issue with increasing prices these days, if you have a fluctuation provision in there, those are great to take advantage of at this point in time. It's built in and it will avoid disputes on pricing issues. So very key, particularly for long-term supply chain contracts. You can do this with first-tier suppliers, but this can also cascade down your supply chain to second and third-tier suppliers. So, of increasing importance, particularly in our current economic environment. Second thing that I want to talk about or emphasize as a key issue that we've seen in supply chains and supply chain disputes are force majeure or change in law contracts. Again, these are critical to supply chain contracts. Through COVID, through the Russia-Ukraine conflict with sanctions, natural disasters, geopolitical crises, we have seen a wide variety of situations where force majeure clauses have had to be utilized. And we have seen a wide variety of force majeure clauses in terms of how they are drafted. Here, I'll highlight a case that came out of the Ontario Superior Court in October of 2022, and that's Porter Airlines versus the Newport Aviation Group. In that case, Porter had stopped their services at Billy Bishop Airport in March 2020. They stopped it until roughly September 2021, and then they invoked their force majeure clause with the airport. That was contested based on the terms of the force majeure clause itself, and the Ontario Superior Court looked at it and said, in fact, this is not a situation of force majeure based on the terms of your contract. So they reviewed the law of force majeure and concluded, and this is largely in line with other Canadian jurisprudence and jurisprudence on a global scale in relation to force majeure, that it's really the terms of the contract itself. So just because there might be a significant event, if it's not drafted properly in your contract, you will not be able to benefit from that clause. So of critical importance, really needing to ensure that the drafting is crisp. So if you haven't revised your force majeure clauses, particularly in relation to suppliers, and again, we're talking about COVID, we're talking about geopolitical events like Russia, Ukraine, we're talking about national disasters. It should be inclusive of all of these things. Again, a great way to avoid a dispute or avoid trying to invoke such a clause and have it be rejected by either a Canadian court or a court in another jurisdiction. Another case that I'll highlight here is an English case that came out in 2022. Very interesting, that dealt with the implications of sanctions and payments in different currencies. That particular clause had a reasonable endeavors provision where you had to reasonably endeavor to overcome a potential force majeure. In that case, the Court of Appeal in the UK said that even though the contract was written out for payment in US dollars, they said that a reasonable endeavor was to pay in euros. So again, key in the drafting, and that is what both of those decisions really emphasize, that it's the provision itself. You have to look at it. There's no general principles that are going to be applicable here other than those of contractual interpretation. The last thing I would like to talk about here, and this segues nicely for a discussion that Tom had, was the rise in ESG claims. There are a multitude of ESG claims, so I'm just going to highlight a couple of them. First and foremost is false and misleading claims, false and misleading marketing. In Canada, historically, over the past few years, we have generally seen those go to the Competition Bureau. Here I'll highlight a complaint that was filed in December 2022 against the Sustainable Forestry Initiative, claiming that their certification was not in fact sustainable, as the certification that companies would achieve did not require any sustainability characteristics. So we're seeing an increase definitively in greenwashing type claims. We're also seeing an increase in claims based on the actions of your suppliers or of your subsidiaries. So even outside of Canada, again, looking at the totality of your supply chain. Well, there has been some litigation historically in Canada on these points, particularly in regards to human rights, international human rights issues. where a supplier might have been involved in actions that are potentially in violation of international human rights claims. Those have been historically challenging to bring in Canadian courts for a number of issues, particularly jurisdictional issues. We have actually not seen one of those claims move from tip to tail or from start to finish. They've been settled, generally speaking, after the jurisdictional phases. However, I would point out that in 2022 or in 2021, Canada brought online the Ombudsman for Responsible Enterprise. That does have a dispute resolution function, and over the course of 2022, that ombudsperson received 17 different complaints and 80 different inquiries, and that is in relation to events that occurred outside of Canada by either a subsidiary or a supplier. So disputes relating to the full supply chain are expected to increase over the course of the next few years, and particularly this alternative dispute resolution mechanism at core. A couple key points there. Again, diligence is key. Diligence in your suppliers through questionnaires or third parties, always a good thing before you enter into those contracts to avoid potential disputes. Cascading codes of conduct. So if you were going to enter into an agreement with a supplier and something occurs, having your code of conduct be applicable is always a good practice point to be included in those contracts. And also the inclusion of suspension provisions, termination provisions, and liquidated damages in the events of an environmental claim or a human rights claim are key ways to mitigate the risks there. That is a very brief and sort of whirlwind tour of supply chain issues. I would be happy to field any questions, but for the time being, I will pass the presentation off to Raphael and Brandon.
Hello. My name is Brandon Barnes-Trickett. I am a partner in the Toronto office, and our area of practice is financial services, disputes, and investigations, touching on the financial services industry and insurance. And I'm going to cover the first two bullets, and my colleague Raphael Egan will cover the second two. And I'll speak rather quickly as we are running towards the end of our allocated period of time. But of course, if questions arise, please feel free to use the chat or contact us around this presentation to discuss further. Crypto is a topic of significant conversation in 2022. Obviously, seeing the insolvency of FTX in the United States revealed how contentious matters might arise from the advent of crypto as an instrument and as an industry. The Canadian regulatory capture, and this might not surprise you, is much smaller, with a smaller footprint, where litigation relevant to cryptocurrency holdings is likely to arise is twofold. From a regulatory perspective, the seminal guidance on this, which remains Staff Notice 21-330, which came out in the fourth quarter of 2021, sets a bar for the advertising practices, a low bar, the minimum bar, for advertising practices as they adhere to marketplaces who have registered for exemptive relief to get permission to offer as a market themselves in Canada to those who wish to purchase, trade, and hold cryptocurrency assets. That's one feature. And the most interesting element of their business, I think, and something we'll see develop a little bit, is the way in which those markets hold themselves out as being able to provide liquidity in the form of stable coins. And a stable coin is a type of cryptocurrency that is effectively a derivative. It is priced with reference to some other asset. Tether and US coin are perhaps the most prominent, the latter of which largely tied to the value of the US dollar. And so they have that form of a derivative. And given that the one significant insolvency we've seen was effectively, has many causes, but rooted in a liquidity event, the increased provision or availability and convertibility to the stablecoin formats is something that's being represented increasingly by crypto marketplace participants. And whether or not a marketplace can in fact make that market in the way that they describe is something that is yet unseen. a feature of a cryptocurrency marketplace effectively is that they combine, from a regulatory perspective, elements of being an issuer, a promoter, a dealer, and a market maker. And that's relatively unique. And so the regulatory challenge there of how to balance all of those interests and regulatory valences while continuing to encourage at least activity in the cryptocurrency market or make it available to Canadians who want to participate. That's the challenge going forward. So that's the first aspect of it, the regulatory piece. The second aspect of it is in the investment advisory space. We have seen in past times of higher interest rates, a desire on the part of non-traditional investors in non-traditional investments to pile in for obvious economic reasons. And a feature of investment management in Canada is that those investment managers who are regulated as such have a fiduciary duty, but an investment advisor, someone who advises, can acquire, in fact, a fiduciary duty given the nature of the relationship that they may have with the parties that they are advising. And where there is a non-traditional asset or position taken, past relationships that would not have been seen as being anything more than the traditional advisory relationship with a client for an advisor could be seen differently if the asset mix changes. And so even if an individual barges into the office of their investment advisor and demands a position in crypto because it's the hot new thing, and the advisor advises against it and makes the purchase, there may still be, given the particular nature of that asset and the particular nature of that relationship, the risk of an allegation of fiduciary duty arising. It's always a potential issue for investment advisors, but the risk is heightened in circumstances where non-traditional positions are taken. So that's cryptocurrency. Moving on to the second bullet, I'm just going to deal with the ESG piece. So we are in a period of regulatory flux. We saw in January of 2022, the CSA, the Canadian Securities Administrators' guidance for ESG disclosure was proffered for investment funds, and that's been noticed in the funds industry, less so in the marketing, those who only market those funds. And that was following an industry consultation process that lasted for most of 2021, in which this firm was heavily involved. And following that, and this is dealing with the E in ESG, National Instrument 51107, which has been in final draft form for some while, has been lingering, and that will provide the overall parameters and regulatory lodestar for climate-related disclosure. The holdup has been the exercise of the ISSB, which is the International Standards Sustainability Board, which is a body that tries to harmonize technical standards for disclosure. We expect in 2023 to see some of their work product, which is designed again at market harmonization. That may influence the final form of 51107, and I think it's even odds that we get to the end of promulgated 51107 this year. What parties need to really worry about here is if you are in the industry of relying on ESG disclosure for the purposes of your business. And so if you are in an ESG business, an ethical investment fund, to use now a somewhat dated term, for example, then the threshold of materiality as to your disclosure in this regard is met ostensibly by the very virtue of that being your market position. The direction of travel, however, is to see other investors who are investing in industries that do not traditionally hold themselves out as having a particular ethical valence, caring enough about the subject matter of ESG disclosure for it to meet the common law materiality tests that, of course, was famously set in Vancouver Airport Centers and Sharbairn, other way around, Sharbairn and Vancouver Airport Center. So we might see, if not this year, but in the coming couple of years, an evolution of the test of materiality, which will have a consequence for anyone who is seeking to launch a civil claim on the back of regulatory disclosure from an issuer who offered securities on the back of that disclosure. So that's my summary of those first 2 points, and I'm now going to pass over to my colleague, Raphael Egan, who will deal with the next two.
Thank you, Brandon. My name is Raphael Egan. I am counsel in the litigation group. I sit in the Toronto office. A key focus of my practice is the securities regulatory and enforcement space. Prior to joining Dentons, I was enforcement staff at the Securities Commission here in Ontario, and I was a senior litigator at one of the major banks where I advised on a number of wealth management and capital markets consumer complaints and managed the regulatory matters involving securities commissions and the SROs. So I'd like to speak to you about two topics which are relevant in the enforcement space and then provide a couple of takeaways for you. So the first topic is going to be in relation to the new self-regulatory organization, the new SRO. And the second will be related to the continued payments made under the OSC's whistleblower program. So in regards to the SRO, as of January 1st, IROC and MFDA were replaced by a single entity called the new self-regulatory organization. Very formal name, but it won't last. It's just a temporary placeholder until the SRO comes up with an official name later this year. So for the time being, not much has changed. The pre-existing MFDA and IROC rules remain in place, along with the universal market and integrity rules, which were previously enforced by IROC. The MFDA and IROC rules will eventually be merged under this new SRO. So it'll be really interesting to see how the new SRO's enforcement procedures evolve and where their focus will be. That's something that we're going to be following very closely. I expect to see a continued emphasis on investigations related to seniors, as well as firm supervision and conflicts cases, amongst others. Moving on to the whistleblower program, the OSC recently provided data regarding its whistleblower program to date. This program is unique amongst Canadian securities regulators, and it was created in 2016. The program offers rewards of up to $5 million for tips that lead to enforcement action. And they're typically, the OSC staff is typically seeking information related to insider trading or tipping, undisclosed conflicts of interest, fraud, misleading corporate and financial documents, trading related misconduct, and matters like that. So in this update, the OSC confirmed that over $9 million have been paid to about 11 whistleblowers over the years, and roughly $50 million in sanctions have been imposed against 19 respondents where whistleblower information has been provided. The most recent whistleblower received a payment of $481,000 for the assistance that they provided to staff. And with payments like this being publicized, I expect the flow of information to the program to continue, and it's only a matter of time before we see our first payment north of $1 million. I don't know if we'll get whistleblower payments of the same magnitude that the Securities and Exchange Commission gets, but it does appear as though these payments are rising. So the takeaways I want to provide from the above, overall, I think it's just the message that firms need to continue their culture of compliance. This means maintaining high standards regarding their policies, procedures, and practices, which govern their regulated employees and businesses. In particular, these policies should be looked at and updated often, and knowledge of and compliance with the policies should be continually assessed. Further, to the extent that any issues are identified, they should be moved on promptly and thoroughly. Related to the whistleblower program, in light of its continued success, firms should ensure that their employment agreements and their internal policies are compliant with the anti-retaliatory and disclosure provisions in the Securities Act. As well, their internal reporting should be well thought out and made known within the organization to encourage internal reporting instead of having employees resort to the whistleblower complaints program. Ultimately, the faith that these employees are going to have in the internal reporting programs will be influenced by the firm's culture of compliance, which is, of course, set at the highest levels of the organization, the tone from the top. Thanks. I'm happy to answer any questions, and I'll pass things on to my colleagues, Michael and Matthew.
Thanks, Raphael. Thanks, Brandon. My name is Matthew Fleming, and I'm a partner here in Toronto. My practice focuses on class actions, securities litigation, product liability, and professional liability matters. And I'm joined by my partner, Michael Sestito, who's going to lead us off today with an update on professional liability matters.
Thanks, Matthew. In addition to Matthew, I am one of the co-leaders of the National Professional Liability Group here at Dentons Canada, with an emphasis on representing engineering and health professionals on both sides of disputes. And I also have a large infrastructure practice as well. Today, I will be discussing the three Western cases that we focused on in our year-end review of critical decisions in 2022 concerning professional liability. Now, in my view, the most significant decision that has the potential to completely change the landscape for professional discipline in Canada is the case of GINA and Alberta Dental Association and College. I do believe this to be a bit of a watershed case. The facts are not really that important. There's a regulated professional who appeals various disciplinary findings from an administrative tribunal. But what was really interesting was how the court approached their ruling with respect to costs in that case. The Court of Appeal essentially ruled that costs in an administrative disciplinary proceeding ought only to be awarded against professionals where there was a compelling reason to do so. In other words, the presumption is that no costs ought to be awarded. The costs of these administrative proceedings were part of what the Court of Appeal of Alberta described as the, quote, privilege of self-governance, end quote, for professional regulatory bodies. Now, this is a rather significant departure from the previous practice where costs were more of a given, even in the face of relatively minor offenses. Now, this might not seem like a big deal, but really it is, and let me explain why. Imagine if you are a doctor or a lawyer or an engineer or really any sort of professional, which I know a lot of people on the call today are. Now, if you imagine that your college or regulatory body requires you to perform some sort of administrative task like record keeping, charting, keeping clients' notes organized in a certain way, and most regulatory bodies do. Now, if you imagine that you're accused of professional misconduct on a whole host of items, including the fact that your charting or your notes were not up to standard. Now, prior to this case, you might be worried about about contesting charges of more serious offenses in open hearing because of the very real possibility that you would be found guilty of unprofessional conduct for minor administrative items, which would lead to a likely costs award, and those costs awards can be rather punitive. Even if you were successful on a host of other more serious charges, there was that risk. Now, at least in Alberta, there is no longer this presumption that costs will follow a finding of unprofessional conduct. And this empowers professionals to push back on substantive allegations and also will force disciplinary bodies to perhaps be a bit more judicious in prosecutions. What remains to be seen is whether this privilege of self-governing concept will be applied outside of Alberta. And on that note, I can report that just today, the Supreme Court of Canada has refused leave to appeal the decision. So it will remain the law in Alberta. And I do believe that subject to statutory differences, there's a very real possibility that other jurisdictions could adopt it. Now, I know we're running low on time, so the other two cases I won't spend much time on. They're Ashraf and Zinner. The takeaway there is that you should not treat a legal malpractice action as a full indemnity for all losses in a transaction. You want to look at the causal chain there very carefully. And then there was Goodwin and Alberta College, an association of chiropractors, and other than some salacious facts, I think the only real takeaway there is that administrative tribunals really are the exclusive and first jurisdiction of remedy for administrative disciplinary issues, and premature applications to the court will not be treated kindly. So that's my cases. I'll turn things over now to Matthew to carry on.
Thanks, Michael. The other two cases we want to cover briefly are set out here on the slide. The first is the decision of the Court of Appeal for Ontario and Tenassean College of Dental Hygienists of Ontario. Very briefly, in that case, a dental hygienist lost his license to practice after providing treatment to his partner with whom he was having a relationship and who he eventually married. However, because the parties were in a sexual relationship, it was considered sexual abuse, as that term is defined under the Health Professions Procedural Code. Of course, this decision doesn't only apply to dental hygienists, but others who are governed by the code in Ontario, and there are several professions to which that code applies. This simply reinforces the fact that the professionals in Ontario have who are subject to the code are dealing with a zero tolerance policy, and the courts and the colleges will enforce a bright line rule regarding sexual abuse, even where that relationship, of course, is consensual. And there is now a limitation under the code for spouses and established common law relationships of 3 years that didn't exist at the time this case was heard. But the takeaway here is that there is this bright line code that will be enforced, and I expect that's the case throughout the country. Switching gears to the accounting profession and the decision of the Saskatchewan Court of Appeal in Coraluk and KPMG. In that case, the plaintiff was an investor in an entity which became insolvent. The investor commenced a proposed class action against the directors of the entity and its auditor, alleging breaches of various duties owed to the plaintiff and other shareholders. Subsequent to the issuance of the proposed class action, the company's board of directors approved a voluntary liquidation and dissolution plan under the provisions of the Saskatchewan Business Corporations Act. And the liquidation plan, as typically the case, required that everyone with a claim against the company had to file proof of it by a certain deadline, failing which that person would be barred from seeking to enforce the claim. The plaintiff in the class action successfully argued that his claim was excluded from the liquidation proceedings under the corporate statute because the claim sought damages only against the auditor and directors, not the entity itself. And the court determined that the broad authority it had under the corporate statute to make orders in liquidation did not extend to a power to order that the claim against the defendants in that case be proven in liquidation. And the court found this was the case even where the defendant had a right to seek contribution or indemnity from the corporation. So the takeaway here is that that decision is likely to apply in the context of liquidations under the corporate statutes in BC, Alberta, Ontario, and other jurisdictions, because those corporate statutes, at least in that respect, are substantially similar. Having said that, I should emphasize that there is nothing in this decision which distracts or detracts from the principle established in the leading Supreme Court of Canada authority in Hercules Management, as reaffirmed in the Livent decision with which I was involved, that auditors do not owe a duty of care to investors in respect of their investment decisions. Ultimately, as a result, in my view, the claim against the auditor should fail for that reason in this case, but at least it was not caught up in the context of the liquidation plan under the corporate statute. So thanks everyone for your time today. With that, I'll turn things over to my colleague, Lori Livingston. Thank you.
Hi, everyone. My name is Lori Livingstone. I am a partner in the Calgary office, and my practice is a mix of commercial litigation and administrative law. I'm going to cover off just some quick developments in the administrative law space today. As anyone who practices in the space knows, 2019, we had the Vavilov decision come out, which fundamentally changed the framework and sought to clarify it. In the years since that case has come out, we've seen about 200 appellate level decisions each year that cite it. So that body of case law is developing quite nicely. This past year brought two significant administrative law decisions from the Supreme Court of Canada that I'll touch on. And it was also a year where we noticed a trend, and building sort of on what Michael was just saying, particularly in Alberta, with appellate courts setting out their expectations for administrative decision makers with a theme that I'd loosely describe as a push for administrative decision makers to up their game a little and be a bit less casual in their manner of decision making. So I'm going to go a little bit out of order for what's on the slides and touch on the SOCAN decision first. It's a decision that in substance won't matter to a lot of people. The biggest thing that folks practicing in this space need to know is that there's now a sixth category of correctness. It won't actually apply to most people. So changing from saying there's 5 categories to 6 will be, in most factums, will be its impact. But it just comes out of what was probably an oversight in Vavilov. The SOCAN case involved decision of the Copyright Board and under the Copyright Act. And it's an issue where the courts and the Copyright Board had concurrent jurisdiction for a particular interpretation point. So that issue of concurrent jurisdiction now joins the previous 5 categories set out in Vavilov with a correctness review. I think more interesting and likely more important case for people practicing in the administrative law space to know is the Abramets versus Law Society of Saskatchewan matter. And that involved a revisiting of the question of when is delay an abusive process in administrative tribunals. And the case came out of an issue that primarily dealt with trust accounts, but it took more than 6 years from the initial investigation beginning to the decision being made. And the lawyer involved challenged the process, the delay on a number of grounds, and was seeking a stay on the basis that it was so extensive as to constitute an abusive process and a breach of procedural fairness. And the Saskatchewan Court of Appeal, I should say, the Law Society initially denied the stay. The Saskatchewan Court of Appeal allowed the appeal in part and spoke to what they viewed as a shift in Canadian jurisprudence towards sounding the alarm on the need for more timely justice in all areas of the law. And they referenced the Jordan decision doing that in criminal and felt that there needed to be a greater push in all other areas. The Supreme Court of Canada, quite interestingly, wasn't willing to make that shift. And they, the majority, what it characterized as reaffirming the Blencoe decision, although I tend to agree with Justice Cote's dissent a little bit on the point. They reaffirmed the test and found that the law in Canada remains that a delay will only be an abusive process where there's some actual prejudice. So hearing fairness has to have been compromised, or there has to be some other significant prejudice resulting from the delay in order for it to be an abusive process, in order for it to be a stay. So the law hasn't changed from Blencoe, but we're not going to see Jordan-like time limits imposed in administrative proceedings. I will say for anyone who's dealing with a delay issue, there are still some really useful points in this case, and particularly in the dissent of Justice Cote. So even if you're not able to go for a stay on that basis, there are other remedies that can be pursued, and the case is pretty helpful in that sense. The other trend, and again, I said particularly in Alberta that we saw, was the Alberta Court of Appeal really giving some direction to administrative decision makers about what is expected to constitute a reasonable decision under the new Vavilov framework. So 2 cases of note there. First, the Cavendish Farms case, where the Court of Appeal does some really nice analysis building off of Vavilov in setting out the clear expectations. Most people would be familiar with decisions that come out that sort of cite the statutory framework, repeat the facts and arguments that were made, and then give you the decision. But it's missing the link of how they got to the decision. The Alberta Court of Appeal in this decision really takes the decision maker to task and says, for it to be reasonable, there has to be a rational chain of analysis that's evident in the reasons. And otherwise it will be, as it was in this case, sent back. The other case that's cited there is the Normco case, and it is insightful for circumstances where a lot of times within administrative bodies, people are performing multiple functions, some of them adjudicative. And the court here provides some guidance on keeping those roles straight. And in this case, the appeal procedure involved a board hearing the matter, then the decision actually being made by the minister. So recommendations and reports were sent up to the minister for decision. And in that package, the board had also sent what it thought was a confidential briefing note And the Court of Appeal said that when you're operating in an adjudicative fashion, you can't also be an advisor to the minister in that capacity. You're part of the adjudicative process. And so the entire package, including the briefing note, was part of the record of proceedings and needed to be disclosed. So yeah, overall, I think we'll see it in other areas going on, that reasonableness is going to require a bit of a higher standard, and we're seeing that put from the Court of Appeal. And any other questions, feel free to drop them in the chat and we'll be happy to answer them. And with that, I will pass off to Pierre and Ekin.
Okay, well, good afternoon, all participants. My name is Pierre Grenier. I am a partner in our Montreal Dispute Resolution and Arbitration Group. As a point of interest for the field of arbitration, I would like to review with you a decision rendered by the Supreme Court of British Columbia in February 2022 in the matter of NROX, Energy and Mining Group versus Sadad. In this matter, NROX was seeking the recognition and enforcement of an international award issued by an arbitral tribunal under a contract subject to Swiss laws. The BC Supreme Court had to determine whether the recognition and enforcement of the arbitral award would be contrary to Canadian public policy as the possibility of double recovery. Here are some of the relevant facts of this matter. The parties form a business relationship. NROX made a loan to Sadad to purchase equipment for the business venture. After Sadad relocated the equipment to a different country without NROX's knowledge or consent, NROX initiated arbitral proceedings in Geneva. The arbitral procedure orders Sadad to pay $4.8 million as repayment for the equipment, and the arbitral tribunal declined to decide whether the amount paid for the equipment should be set off against the balance of the loan. You should also be aware that in different courts in Dubai, court proceedings, NROX seized the equipment and the shares of the entity incorporated as a result of this business relationship. Essentially, the BC Supreme Court ruled as follows. As a principle, it is rare for a court not to grant recognition and enforcement of a foreign arbitral awards. The BC laws, as well as other jurisdictions in Canada, provide narrow exceptions where this is not possible to obtain recognition of an international arbitral award. I mean, like fraud, breach of natural justice, and registration of an award that would be contrary to public policy. Regarding this last argument, it was said that the courts will need to be convinced that the award fundamentally breaches justice and fairness and amounts to conduct that our court would not tolerate. Sadad argued that the local recognition and enforcement of the award without first valuing the equipment and shares seized by NROX as security for the loan would breach public policy, and the value of the seized property did not exceed the value of the award, which represents double recovery. The court rejected that argument as Mr. Sadad failed to raise the issue of obtaining evaluation of the equipment during the arbitration, including other related court proceedings between the parties. Therefore, there was no evidence of double recovery before the BC courts. What are the takeaways from this decision? First, there is a high bar to meet in order to set aside the recognition and enforcement of an international arbitral award. Local enforcement of an arbitral award, possibly amounting to double recovery, does not automatically meet the threshold to establish that enforcement of an international arbitral award would be contrary to Canadian public policy. Third, relying on issues that should or could have been raised during the arbitration will also not support a public policy defense. And fourth and finally, in drafting international arbitration clauses, it is important to look at laws applicable to arbitration and to the arbitral tribunal, the laws applicable to the seat of the arbitral tribunal, as well as looking at jurisdictions where an award would need to be enforced. Thank you, and I will now pass the floor to Aiken for the next cases.
Thank you, Pierre. Hello, everyone. My name is Aiken Sinar, and I'm an associate in our Toronto office. My practice focuses on litigation, commercial arbitration, and investor-state arbitration. We've seen a rise in arbitration in 2022, and the decisions I will present today are great examples of this trend. Let's start with Peace River and Petrovest decision. This is a Supreme Court of Canada decision concerning arbitration in an insolvency context. Peace River is a partnership established to undertake construction works, and Petrovest is Peace River's subcontractor. When Petrovest was placed under court-appointed receivership and claimed amounts due under various contracts and purchase orders, Peace River and its partners applied for a stay on the grounds that these claims are subject to arbitration agreements. The Supreme Court of Canada found that an otherwise valid arbitration agreement may, in limited circumstances, be inoperative or incapable of being performed. Here, looking at the facts, the court held that the arbitration could compromise the integrity of the receivership proceedings because the arbitration agreements were consisting of multiple overlapping arbitral procedures, and this would affect the efficiency of the receivership proceedings. So the key takeaway is that businesses entering into arbitration agreements should be aware of the risk that if the counterparty becomes insolvent, the arbitration agreement may become inoperative. And parties should consider drafting arbitration agreements favoring common rules, common arbitral procedures to keep the arbitration simple and efficient. The next decision that I will discuss is Tall Ships Development and Brockville, the city of Brockville. It's an Ontario Court of Appeal decision reaffirming the court's narrow basis for setting aside arbitral awards. The matter is about a PPP project, and it's a PPP between the city of Brockville and the Tall Ships. And as in many construction projects, various disputes arose between the parties. And Tall Ships submitted these claims to arbitration. The arbitrator dismissed Tall Ships' claim, and Tall Ships decided to appeal the arbitral award to the Superior Court of Justice. And spoiler alert, the arbitration agreement only provided for appeals on questions of law. Well, the application judge found in favor of Tall Ships and set aside the arbitral awards. But the Ontario Court of Appeal held that a question of law for the purposes of Arbitration Act means only an extricable question of law and not questions of mixed fact and law. That's to say, only questions that are capable of resolution without looking at the facts are appealable as question of law. The key takeaway from Tall Ships is that the parties should pay close attention when drafting their arbitration agreement, especially the potential appeal route. With that, the floor is yours, Mark. Thank you very much for listening to us.
Thanks, Akin, and thanks, everyone, both clients and colleagues for attending, and we hope the presentation was beneficial and informative for you. And thank you, of course, also to my colleagues who presented so thoroughly over the last hour and a half. Of course, if you have any questions, there have been a number posted through the Q&A function, many of which have been answered and which we will continue to answer after the session. Again, you will receive a copy of the presentation and as well a copy of the video recording with, as you see on the screen here, the particular and direct contact information for the folks who presented on each topic. Please do feel free to reach out as often as you would like to my colleagues to answer any specific questions that you might have. And with that, we will end on time and with a wish that you all have a great rest of the week, and hopefully wherever you are, it is spring-like this weekend. Thanks again. Have a great rest of the day.